right people without the right salaries. And this past year, we were able to adjust our salaries more in line with state government salaries. We're nowhere close to the private sector, but we don't expect that. We don't do it for the money like you all. We do it because we feel a calling to do what we do. But that being said, we were able to put those salaries more in line with state government, and you all have supported our continuing to do that. So that is the far and away most important thing at our agency, because we can't do what we do without the right people there. So thank you for that. And in order for us to do what we do have to be able to try cases. So my only request this year, in addition to what we have in the elbow proposal, is to add an additional $45,000 in for litigation cost. There was not a dollar amount set for litigation cost. And of course, any of you all have been anywhere near the courthouses know that trying cases isn't cheap. We actually, at the commission, are able to do it less expensively than in the out in the real world, as we say, because we have a smaller panel, we have fewer witnesses typically, but we do have witness fees, we do have court reporter transcript fees, and we have court reporter fees, none of which are cheap. So we average somewhere in the neighborhood of $5,000 per case to be tried. Right now, as we sit here today, we have 9 formal complaints. 4 of them are already on our trial docket set for trial, and I don't have the money to try them. And if you multiply that times the 4, then I've got $20,000 shortfall. And that's if the 5 don't, the 5 remaining don't go to trial, then all I need is 20. But I bet those other 5 are going to trial, which means I need 45 for those to cover the litigation costs. I did want to point out, because I have been in front of you all many years talking about our decrepit old vehicle that is broken down, and you all graciously gave me the authority to buy a new one, and then COVID hit and there were no new ones to be purchased. So we did end up giving you back $35,000 out of last year's budget because we couldn't find a car that we could buy. And we still have that same problem. So when we need one, we'll be coming back and asking for that additional money again. But I don't foresee that anytime within this fiscal year. But I did just want to bring that to your attention, that you did cover me on that, but I had to give it back, and that's why. Any questions?
That's strange, isn't it?
Yeah, that you can't find a car? Yeah, I have money in my hand. I'm ready to pay. No one. Okay, well, I'll just give it back to the legislature. That's exactly what happened. I do. I do.
Do we have any questions? Any questions, any concerns? Okay. Well, we do thank you.
Thank you
so very much.
I appreciate you all. I'll leave these a few extras in case you all need them.
Oh,
You need them?
yeah. Okay. No, you got to.
We have.
Okay. Well, so the bar has a question.
Yes, sir.
I see the complaints are up by 108 or 68%. What's the?
I think it's twofold. I think number one, it is somewhat COVID related, and I know we all kind of blame everything on COVID lately. However, the court systems are having to implement measures that the general public is not used to, as in, I'm sorry, we can't have that many people watch a trial, or we can't have a trial yet based on COVID restrictions. So people not having their cases heard and having other COVID related complaints, I think that's part of it. The other part is, as a benefit of COVID, if there is such a thing, because we have become so streamlined and so automated that if you have an internet access, you can get a complaint to us just like that. We have our complaint forms online. They self-populate in our office. So it's a whole lot easier to file your complaints. So I think twofold. One is a benefit of COVID, and one is a detriment from COVID. And other than that, I don't know. It just kind of ebbs and flows.
So I guess COVID, so people just couldn't watch the trial and be a part of it. So it really wasn't a judge, basically worked orders from the Supreme Court justice.
Right, right. That's exactly it. And a lot of it related to the evictions, which of course the judges had no control over. They were enforcing executive orders and such. So
Do you think that will go down? anytime soon, or-
I anticipate that it will go down some, but I don't know how much. Yeah, we were not expecting a 68% increase, but also to the benefit of having the right people, not one complaint from my staff. That we have all just taken it in stride. And the commission that hears more cases per meeting even, the commission just handles it. Our meetings are longer, we do more work, and everyone has just kind of taken it in stride. Thank you. Any other questions based on this? Right, thank you. Happy Sunday to you. Good to see you.
Post conviction. Public defender, state public defender.
I thought going to a budget meeting on this. 16.
I'm going to check this out. Okay.
Yes. Okay. Okay, good morning. I don't know if this is on or not. Okay, well, I'm Andre Degree. Andre Degree, State Public Defender. Thank you for taking the time, and special thanks to Senator DeBar for coming and finding me. I was lost down the hall. I want to first briefly, I was already told on the other side when I gave my handout, they said it's 6 pages long. I filed briefs in the Supreme Court. They call them briefs. And I said, oh, should it be longer? And they laughed at me. So I'm gonna run through this quickly. The first page is what I want to talk about with you today. The second page is important. It's the history, the background of the public defender system. It's the highlights of years of study by a public defender task force that was put together by this body, chaired by members of the Supreme Court, and an independent investigation of our public defender systems by a group called the Sixth Amendment Center. It was funded by the Department of Justice. The narrative comes basically from our submission to the joint committee, but this is specifically tailored to what we're asking for in pilot projects, an additional $2 million, what we have right now, so that we can establish some pilot projects to improve indigent defense across the state. Because Mississippi, we talk about a public defender system, we don't have a system. In the back of the packet, there's a sample budget spreadsheet of what it would look like, what the counties look like now, and what we're proposing. This is in the 15th, 3 of the counties in the 15th judicial district. The reason we using those, it's Pearl River, Lamar, and Marion County, is because Judge Harrell, the senior judge there, was on our task force. District Attorney Hal Kittrell was on the task force. And so when we started pulling numbers together, working with the local public defender in Pearl River County and Lamar County, where they do have full-time positions and also part-time positions, and the judge and the district attorney. So we're further along in pulling numbers together to kind of give you a visual of what we're talking about, we think we could do to improve indigent defense. Last page is just a recent news article on what we're doing in child welfare cases, that the legislature in 2018 started giving us funds that we could go in and assist local systems to improve or to provide representation to parents in child welfare cases. So they're at risk of losing their children, or maybe they've lost their children. And we go in from Jackson, all we're doing is training them, providing technical assistance, and importantly, money. And that's what we want to do with these pilot projects for criminal defense. Constitutional right to criminal defense. There's not a constitutional right, but there's certainly a justice issue in the child welfare cases. So what we're doing now, and you'll see in the first line, if all you read is the first line, I'm telling you, we're sufficiently funded to keep doing what we have done. And so the question in anyone's mind who doesn't get past the first line would say, why is he coming over here to talk to us if he's already sufficiently funded to do what we're doing? So very briefly, what we're doing is we're assisting in death penalty cases. We're handling all of the death penalty direct appeals. We're handling all felony appeals, and we provide training and technical assistance to lawyers across the state doing any type of indigent defense, full-time, part-time, doesn't matter. But we're not doing any direct representation or even supporting direct representation. So I say we must do more. You look at the research, we must do more. This is why we must do more. This is the front page of today's Clarion Ledger. They're now calling it a dead zone. In our earlier research, we called it a black hole. People are sitting in our jails because they can't afford bail and they don't have lawyers because they can't afford a lawyer. So they're sitting in jail for months, sometimes years. No doubt there'll be a lawsuit here. We've had lawsuits in Chickasaw County. We've had lawsuits in Scott County. It is going to continue until we fix this dead zone, fix this black hole. And so we have a plan that is significantly less because we're just starting. We're talking about phase 1 with some pilot projects. It's less than even what the public defender task force settled on and said this will be a compromise. They were looking at what's done in Arkansas, where there's 100% state funding and complete state control. And then you look at Tennessee, and it's the mirror image of the DA's office. They even elect public defenders there. But the key is it's 100% state funded. The Alabama was, and this is important lesson to learn, Alabama has been 100% state funding of public defense for years, but there was no oversight. And they were spending way more money than they should have been. And they weren't getting the product for the clients that they should have been getting. And so we've learning from others' mistakes. It's sometimes good to be last at the table because you've learned everybody else's mistake. What we are proposing is a pilot project in North Mississippi, a pilot project, and you see the sample budget for the pilot project in South Mississippi that would allow smaller counties. You know, we have a good functioning public defender in Harrison County, in Jackson County, places that have a lot of money, and a full-time office here in Hinds County that I worked at, and is a good office where they can afford it and where they have these huge case numbers. So what we're proposing is to help facilitate bringing together smaller counties so that they can have, and it's a mix of both full-time and part-time. That's necessary for some cost control, but it's also necessary for conflict cases where you have lawyers. The one office can't handle every case that comes along. So it's something that's being tried in different places. But when you look at Pearl River, that's moved from 3 part-time lawyers to 3 full-time lawyers. They're funded at about 50-60% of the DAs. And so there's rapid turnover. There are no investigators. There are no social workers. Very limited administrative support. And so what we're proposing is a model, a multi-district model that would bring them up closer to what the DA looks like, but also you're going to have fewer lawyers because you also have to have these part-time or private contractors also. And those would be more experienced lawyers who have established law offices and can handle these cases without the added assistance that we get of a young lawyer in a public defender office. The goals we have, or the biggest problems we see is the early and continual representation, filling this dead zone. That's what we want to do. That's the most important part of our plan. And but essential parts are monitoring caseloads, make sure they have reasonable caseloads, make sure they have pay parity. As you'll see in comparing to what the district attorneys make in our narrative proposal, we're not talking about bringing them up 100% of what the DA makes. The recommendation, and my friend DA Harrell on the task force argued persuasively for, was 90% of what the prosecutors make. I agreed with that, and a lot of public defenders are still not happy with me, but we're talking about getting them much closer than the 50 or 60% they're at right now, and to get them that important support staff, including the social workers. You've done some great work on criminal justice reform in the last few years, and we haven't done reentry investment, and we haven't even looked at the front end where people like Dwayne, who spent way too much time, he shouldn't have been in jail at all. But you have a lot of people who could be safely released from jail until their case is resolved, because half of the people who get convicted don't go to prison. And if you have a social worker helping that person, because we have no pretrial services, if you have a social worker in the lawyer's office helping, and on the back end on reentry, we believe you're going to reduce recidivism, and you're going to have better outcomes and things like availability of drug court that you don't have today because people are just sitting in jail. And I said we have two models, and I mentioned one for the north and one for the south. It could also go in several of the counties in central Mississippi, but we have a special situation in the city of Jackson. And I know the chairman is well aware of this. And so we have, in looking at the Michigan reforms, we have been in communication there. We've actually got a concept paper that was presented to us and put together by the Neighborhood Defender Service, that they believe they can develop a model to be in Jackson. It's probably, if they've transplanted it from New York to Detroit. They didn't bring a busload of lawyers from New York to Detroit. They hired Detroit lawyers to staff the office, but it's the model that is representing people in not just felony cases, but misdemeanor cases. We have too many people. If you go down to Jackson Municipal Court, you will actually observe this, that someone is brought out to the podium, a lawyer stands with them, and then that lawyer goes and sits down, and another lawyer comes and stands with them, because we've got a city public defender and a county public defender. And so what they're able to do there is bring everybody under one roof, a misdemeanor defender, felony defender, a family defender, what we do in the child welfare cases, so that the client, and this isn't to replace the county public defender office. The county public defender office is overstretched. They can't do more. This is to relieve the burden on the county, and particularly with the increase in violent crime that we've seen, to be able to provide additional representation. Much smaller office than the county office.
So Andrew, you're saying that the cost for the project is $2 million?
What we are asking for from the state is $2 million, and we will, as you see in the spreadsheet, there's more funding in South Mississippi. So the South Mississippi model, if we did that, we'd be funding less than half of it.
Mhm.
But we know that in North Mississippi, in just the preliminary conversations, they're underfunding there. And so we may need to do a little bit more than half. The project for the neighborhood defender in Jackson is the match funds are going to come a small amount from the city, because the city doesn't have much. But the neighborhood defender with private investment will also cover civil legal defense and some of the support costs of opening the office. So what we're asking for in phase one is 3 pilot projects. There'll be 2 million in state investment and close to 2 million in county, city, or private investment. So the 3 program cost is closer to $4 million, but we only need 2 million of the state funds.
Do we have any questions on? So that's your total ask?
That is in addition to our recommendation. It's ballpark of what we asked for initially. We got what we are funded at today in the recommendation, and so we're asking for the 2 million on top of the.
And last year we funded that was was a victim indigent and a lawyer for indigent families. Parent defender.
The parent defender program is under. We are up to about 300,000. We also have some money from Kellogg Family programs that and are still working with the CPS and the Children's Bureau in DC, that we're thinking that they will get some supplemental funds there. So we're not asking for additional funds.
But it's working well, I guess.
It is working very well. And that the news article on the back of the handout is on the Lee County project.
Okay.
We just started Hinds County January 1. And we've been doing this now for about 3 years. And the year over year, so all of 2021, there was a slight increase in foster care population, about 1.5%. And the places that do, and we do have some counties doing parent defense themselves, that there is about a decrease. So about a 1% increase in the total foster care population, about 1% decrease in the counties that are doing parent defense without our help. And we got about a 10% decrease in the counties. We're doing some in South Mississippi, some in North Mississippi, and then we just launched Hines County. And this Lee County experiment is doubling what we were investing before.
Okay. Any other questions or questions? Well, thank you for coming, Andre. Bill.
What I was saying was, they were scheduled, but they're outside now.
Capital Post Commission.
But they were scheduled.
Okay.
Something you didn't, well, anything you did, they just were not here.
Yeah, I understand. Yeah, well, you should have your OBR sheet.
Okay, yeah, I got it.
Who do you want?
Kappa. Kappa.
Yeah, I don't think we have.
Their OBR sheet. Yeah. You have your Capital Post Commission.
Yes.
She's not. She's in the house. Yeah, I passed it out already because I thought they were coming in next. Let me see. Hold on. I probably did.
We're ready? Morning.
Noble, and I'm the director of Capital Post Conviction, and I became the director in August of 2021. And here with me is Denise from Cornerstone. She does purpose walks. She handles our budget. So if it gets to particular numbers, especially those that predate me, I may ask Denise to step in. I'm of course happy to answer any questions, but I thought I'd start by just telling you a little bit about our agency. Created in 2000, and we represent all of the indigent individuals that are sentenced to death in Mississippi. And there are close to 40 individuals on death row currently. And for statute, we represent them until the execution of that sentence or until they are off of death row, or they get into trial, or are exonerated. One question I commonly get, probably from more lawyers than even non-lawyers, what exactly is good conviction and what exactly do you do? And why do you hear terms from the Mississippi Supreme Court like it is a specialized?
Make sure the mic is on and talking to the mic up top. Yeah. Okay, sure. Okay.
And why do you hear things like that this is a specialized and a complex and time-consuming litigation, which you see often in Mississippi Supreme Court opinions. And so I think the easiest way for me to explain it is just, you go to trial and you get convicted, and if you get sentenced to death, you're going to go up on appeal. And everyone kind of sees those are on the record and nothing can be added to the case. But we are different. When you come to us, things can be added to the case. And some things that can be added to the case are newly discovered facts that may prove actual innocence. Or things you hear a lot about on the news these days is DNA evidence or other forensic testing. So we add all that to the case, and what that means is we really do an investigation from the ground up. So we start by reviewing all the records, of course, and in fact, some of the cases they're slightly large. But we have an investigator, and we I'm kind of on the ground person, so we investigate ourselves, and that means talking to clients. If someone from our office is not at Parkman every week, it's I can assure you it's probably every other week. Sometimes we're the only face that our clients actually see. And from there, what we do next is usually talk to the client's family, talk to witnesses either that were known or that weren't talked to originally. And we hire experts. And some of those experts include some you would think, like a forensic pathologist. All of them usually will include some kind of mental health professional, including forensic psychiatrists, neuropsychologists, toxicologists. And all of this is time consuming and all of it is specialized, but all of it is also necessary. Because not only are you just handling these things, right? We have to handle them, but we have to handle them competently, really for two separate reasons. One, because the U.S. Supreme Court says we have to. And so we have to do that to protect the constitutional rights that they're afforded, that were afforded. But we also have to do it in Mississippi. So in Mississippi, you have a right to effective assistance at post-conviction counsel. And so what that really means in simplistic terms is that if we don't do it competently and right on the front end, we're going to do it competently and right on the back end. And that just means you're paying double the cost. So we try to get it right on the front end, but that does mean a tremendous amount of work and a tremendous amount of experts. And one thing I hope the handout contrasts, at least Denise's charts are much better than my words, but I hope it contrasts something that is different from the past couple of years. And that's in the past couple of years, you will see that we had a decrease in travel as well as a decrease in contracts. But that is for a reason, and that is for the obvious reason of COVID. The courts were shut down. We were not seeing as many trials go forward, and thus we were not, most of our cases were stayed. We weren't going to court to argue them. Our PCR dates were stayed because we couldn't go out and hire folks and travel and investigate. And now that is, of course, different. We are back up and running, and we are traveling and hiring folks, and we are seeing due dates come down from the Mississippi Supreme Court pretty often. So another big factor that we have to look at now that has recently increased our workload is the fact that executions are resuming. So Mississippi did not execute anyone from 2012 until November 17th of this past year. And what that means for us, or I guess, start with, in July, we found out that the state has the lethal injection drugs and thus has the means to carry out executions. And what that means for us is that we go back over old cases, because one thing that you get from post-conviction is maybe it wasn't done the right time around. Maybe it was done before the creation of this office. We have to look at those. Or like one I have is maybe the law's changed. And so if the law's changed, that's grounds for another post-conviction motion. So because executions are resuming, we've seen a pretty high increase in our caseload just from this past July. Another thing that has increased our caseload that is important to me both professionally and personally is that we currently are pursuing 2 actual innocence cases. Those, as one can imagine, require a lot of investigation and a lot of preparation. We try to be mindful of that. We secured the assistance of a global law firm to help us pro bono for one of those cases. One will be filed in federal court pretty soon, and one will be filed in state court, I hope, by the end of the year. But those cases are important. I've practiced on both sides of the aisle, and I 100% believe both guys are innocent. And then another thing I think that has really increased our caseload is not only do we just have the regular cases that we would normally have, but we also have, I expect to get 2 new cases towards the end of fiscal year 2022, which will mean that we're working on them in fiscal year 23. So that also has increased our workload. And so we originally were asking for level funding, and I'll let Denise explain the chart on the last page as to why we do have a modified request, but originally we were asking for level funding, and one of the things that our budget analysis cut was the contractual services. And if you look at that in the chart, what they were cutting contractually, we almost hit that even during COVID. So that's not something we could really live on, because if I can't hire the forensic pathologist or the forensic psychiatrist on the front end, I'm going to go to federal court and the case is going to be stayed, and I'm going to come back and then I'm going to have to hire something. But I'll let Denise kind of talk to you guys about the chart on the last page.
Even before I get to the chart on the last page, I want to talk about where we started as we processed this budget in August. We started asking for level funding. We used our FY19 figures instead of as our baseline, because as Ms. Nell's already pointed out, 20 and 21, our expenses were way down. You can look at the chart in the middle page to show what our travel expenses, just for an example. We went from spending $74,000 in 19 to only spending about $14,000 last year. So we needed to use 19 as our baseline. And that's where we started. And that's why we asked for level funding to start with. And then as all of these new cases came up, and as Snell and I started talking about what is on the horizon, we decided we needed another $400,000 just in our contractual. So you will see that. If you look at the LBR, the legislative budget recommendation, you will notice that the recommendation was for considerably less. It appears that why that happened is that this year we still have special fund authority that was left over before the Budget Transparency Act of 17. And so that $215,000 was actually put into our appropriation for FY22. Those funds will not be available going forward into 23. So we're asking for that to be replaced with the general funds. The only other thing that's on the chart, the LBR recommended a 3% salary increase, and we are very, very appreciative of that. And that's why the numbers in the salary recommendation are higher. But we do want to point out that in this office, the attorney's salaries are tied to the district attorney's salaries, and Senate Bill 2066 is out there to raise the salary rates for the attorneys in the in the district attorney's offices. So we've added a column that if that bill passes, then on that last page in the green column, that shows what we would need to keep the 3% raises for the staff, but what it would take to give the attorneys the full pay raise according to Senate Bill 2066.
Okay. Do you have any questions? Okay. Since we're-
Thank you, Mr. Chairman. So how many people are involved? How many attorneys?
We have 5 attorneys, and that includes me. And so usually the way we staff it is 2 attorneys per case. And the death penalty case really needs 2 attorneys on it. And then I try to look at all of them. I'm oddly very interested in rewriting. So I look at all of them before they are filed in front of state law and all of them, so at least someone has some continuity between all the cases and what's going on. We also have 2 mitigation specialists. Mitigation is constitutionally required, and just anything that would give a juror a reason to vote for less than death, we have to investigate that. And then we have 1 investigator, and we have a paralegal, And on contract, we have currently a receptionist. One of the big goals of mine has been getting our files in order. That penalty files are large, they're a lot of office. So we are trying to get those in order right now.
What's the caseload increase? What's the number?
We have, so there are a little bit less than 40 inmates currently on death row. At any given time, we could represent all of them, so not all of them would be active at the same time or represented by us, because sometimes we may have a conflict case or something like that. But you, if the law changes, for example, as I referenced earlier, that gives you grounds to file a successor petition. And I would say not just grounds, it's impact. Practice not to. But so depending on when those things come up, is when the case is active. But as a general matter, we represent all of them.
So I'm looking at the last page, the green is what required the Senate Bill 26 pass, or that you modified it.
The salary line item is if that Senate bill passes.
In the 400,000 roughly increase in contractual, what is that for?
Do you want to talk about that?
Yeah, so the contractual, the recommendation was to lower the contractual. But if we lowered the contractual, we are hitting almost what we hit even in COVID era, where we weren't contracting as much. And one reason the contractual would increase are the kind of factors that are going on right now. The fact that we have executions looming. So if we're filing a successor petition or stay of execution, you have to have an affidavit for those. You have to have an expert. Actual innocence cases, which again, we have two right now. One, we're not paying for the expert, but Proveno firm is require a decent amount of experts.
What is an actual innocence case? What is that?
I mean, just in simple terms, the person did not do it. And one of our guys has been on death row for 26 years and the other has been on death row for 22 years. And I firmly believe that both of them are innocent. And I think we have a pretty good proof that they did not do it. And just, I mean, I can just show you, I'm a visual person, so this is one PCR and it's not even an actual PCR.
PCR post-conviction.
So the post-conviction motion, this is the most recent one we did on New Year's Day. It was a lot of fun. Our deadline was January 4th. So we celebrated in the office by doing a table of contents and table of authorities. But one post-conviction brief, at least the way we're doing it in the office now, is 148 pages, and that doesn't have an actual issue.
And
That 400,000 increase for contractual experts.
Yes.
And if you don't mind, I'd like to just give you one other piece of information. A couple of years ago, we did an analysis of how much contractual cost we had per case. And we found that the cases contractual costs could go anywhere from 50,000 to 335,000 just for one case for their experts.
That's just because of the issues that you may have. I mean, you may have guilt phase may have gone, completely smoothly, and I mean, we have a great criminal justice system. It's the best we have and the best that we can do there. So if you have a guilt phase that's just fine, but a mitigation phase that's not, you're going to have a decrease in contractual expenses. But we don't know we don't know that information until the case comes to us.
Thank you, Mr. Chairman.
Sure. Any other questions? All right, we thank you for coming and we're in touch.
Thank you. I appreciate it.
Okay. The Lone Ranger. Sit right here, please. Page, you sit close to us. Close by, wherever you can get into that deal. We need the handouts for the committee. And we also need the laminations. And the one. All right. Thank you. These laminations. Just them. Thank you. All right. Please. This as well. Y'all need, yeah, well, yeah, please. Whoever needs one. Also, these laminations. Well, hello, Senator. Levar. All right, I need the percentages. I'll use during my presentation. No, don't see them. Okay, good. That's my thing. Got it. Yeah, this is what I'm looking for. We're ready, yes, sir. All right. Members of the committee, I'm Greg Snowden. I am the Director of the Administrative Office of Courts. It's our pleasure to be here. I have several folks here, part of my team as well. Also, Chief Justice Randolph is sitting in. But without further ado, I'm going to get into our budget request for May. You will see it's before you. It looks like this. Looks like this. You will see that we're asking for intervention courts. I'll get into that. It's important for me to point out and important for you to understand. 76% of all we're asking for here, 76% goes to your local communities, your local courts. Very little comparatively stays here. That's important for you. It's critical for you to understand, because I know I presented this budget many years in the House, and it's always the Supreme Court budget. Well, that's not true. It's the courts of Mississippi. And in fact, the Supreme Court technically doesn't even administer it. My office, the Administrative Office of Courts, does that. But in any event, please think of it as the courts of Mississippi. And the great bulk of this goes to your own communities, your own courts. All right, you'll see here that the first thing that we want to present to you is the intervention courts. This is a critical thing for us. I think the legislature has realized that. We've been provided $7 million a year for it. It actually takes a total of $12 million. So this quite simply is a request for the additional $5 million to bring us up to what it takes to operate. We think, and by the way, if you look at the lamination, that's very important. You can look at that later, but that's kind of a success story of the intervention courts. You will see, not only does it change lives, I mean, there's no question, it changes lives, but not only that, it actually is a moneymaker for the state of Mississippi. If you look at that, you will see it's quite clear that that's the case. So we would ask you for that. Also, the youth courts, there's a statutory minimum of 625, the statutory minimum is 2.5 million. And we've been receiving about $1.8 million. This quite simply is to bring us to the minimum amount that the statute requires for youth court operations. And that's an additional $625,000. That again is money that flows to your communities, to your youth courts. It's critical that you understand that. The Parent Representation Program, it's a wonderful program that is being run. It's for parents to represent adults in proceedings where they are accused of abuse, neglect, that sort of thing. It's critical that they have representation just for basic fairness. Also, it makes it work a lot easier if they have appropriate representation. The Casey Foundation has been providing money for that to the tune of $600,000. They continue to do that, but one of the things they've asked us to do is take on part of that, $136,500. Technically, it's not part because they will continue with the $500,000. That the state has some skin in the game. This will allow us to expand to more counties in which the parent representation is operative. So that's very important. We would respectfully ask for that. The CARES Act funding is probably self-explanatory to you. That is money we had available in last year's budget. It has gone away. We do not have it in this year's budget. So therefore, it's reflected there. So as a total, you will see we're asking for an additional $5,766,500 in general funding for the items I've mentioned. And we deduct the special funds that are no longer available. That's an increase of $3.9 million some odd. So that's our request for intervention courts, youth courts. They're very important. Next, I move to salaries. It's important that I emphasize this to you. First of all, you see the judicial salaries. And again, I would simply say that only 16% of that is for judges here in appellate courts. 84% is for your trial judges. And with the January 1 increases, it's 13.8% here and 86.2 for your local trial judges. So that's important. That's how they receive their compensation. They're looking at you to help them out there. So please bear that in mind. You will see that the request here is to meet the State Personnel Board recommendation, which coincidentally works out to be about 6%. You will see here what that is. It's an increase of $1.4 million in the general funds and $1.7 million in special funds. That comes from the judicial operation for a total of $3,158,000. That we believe is essential. We would ask that you please fund that. I would point out to you that's 6%. That's not even inflation at this point. So we would suggest to you that's a deal and you should jump on that. That's what we propose for you to do. That will get us in line with the statute that we passed. I voted for it in 2012. And it's this is what the state personnel board recommends. Also, it's important for me to point out the special judges here. That's $475,000. There have been ideas floated, good ideas, for the court to appoint, for the Chief Justice to appoint additional special judges to handle different things. But it's important for you to know this $475,000 is normal operations for recusals. We've had an inordinate amount of those because of the number of judges that you have left, over the past few years. And as you'll know, Any new judge coming in most likely is a former district attorney. Certainly he's a former attorney in private practice. He was one very active. So by its nature, there are necessary recusals that come up because of conflicts. This is just a normal expense that we have to spend to keep that even. And the truth is, it cost us about $700,000 each year. This would bring us to a point where we're receiving the bulk of that. That's what we're requesting. But truthfully, it doesn't even necessarily bring us to what the full amount is. We would ask you to do that. We consider that essential. Then you'll see here the totals that I mentioned. Then I particularly want to hammer home, this is essential, our support staff, our state employees that work for us. Unfortunately, inflation is eating them alive. You will see some attachments here to articles about the current inflation rate in this country. You will see these tables beginning here with, it says historical tables for South. That's the South only. You will note, if you look at the last page, that the increase in the South alone has been 8.1%. 8.1%. I wish I could tell you that's going down, but it does not look like it is. 8.1%. If you look at nationwide, it tracks it very closely. It's actually 7.8%. So my point simply is this. We beg you to take 7% as the absolute floor for what's needed to keep our employees even, because in the absence of that, any good things you may do in other programs to increase funding, which is very important, I'm sure, but we're subsidizing it. All your state employees are subsidizing that if they don't at least get to the 7% necessary for them to maintain that. And we would ask you to do that. I want to show you, if I may, we suggest, again, if you see here, it's on here as 7%, which we would treat as an absolute floor. I want to show you what this figure would be at 7%, 9%, 10%, and 11%. And I hand that out to you simply because I'm hopeful that you will want to actually give a real raise, a raise in actual pay to these employees. This is what it would be, just for your information. You need that? All right, yes. Oh, yes, wrong one. Here they are. I'm giving, well, I know I got some more page. Yeah. Anyway, while she's getting that, the point is simply this. If 8.1 is true, then a raise at 9% brings us only to less than 1% in a real raise. So be mindful of that. If you go to 10%, which sounds dramatic, that's less than 2%. And in fact, if you look, even if you use the current federal rate, it's still only 1.5 points. So that's really not much of an increase if you do that. At 11%, it's at least a little short of 3% increase. So be mindful of that. That's absolutely critical that you take that into account. I would say not only for us, but all of your state employees. They're again looking to you to do right by them. And we would ask you please to do that. So you see the total increases in salaries. Again, this is at the 7%, which before $2,500,000 in general, $1,000,008 in special, and $4,004,000 for total salaries for the total increase at 7%. You'll see on the sheet what those would be at 9%, 10%, and 11%. We urge you not only to start the floor, which needs to be your absolute floor, but also devote something to actually a real raise to the employees. We think that's very, very important. You think you move down to travel per diem, for appellate judges somehow or another, and maybe inadvertently, the travel money for your Court of Appeals to travel back and forth to Jackson to meet court, that was omitted in last year's budget. We're given to understand, y'all thought it was in there, well, it was not. And what that means is it's $475 million short, or $475,000 short, 400,000, I apologize, short, that we need to have to bring them up to speed with that. And we would ask you please to do that. That's clearly necessary. We need to expect that to be in there. The out-of-state travel, you mandate as a matter of law that each new judge attend the National Judicial Conference. That's a 2-week intense program. All the judges are required to do that if they need to come to the bench. And again, we've had plenty lately. And that's an expense. We need to pay for that. Y'all mandate that. And that's where judges go all over the country to learn how to be judges. And so that's what that's for. Please add that. As far as the convention, the out-of-state travel there, look, you can ask any member of the bar, any leader of the bar, that the bar convention really doesn't function as it should without the active presence and the participation of the judiciary. They count on our judges for all sorts of seminars, all sorts of panels. Really doesn't function well otherwise. When we were in that situation last year, thankfully, Senator Hobson, Griggs Hobson, reached out to the Judicial College and asked them if they couldn't fund that. He understood the nature of the problem, and thankfully they did. We can't count on that anymore. It didn't come to us. It counted. They paid for it. So we just urge you to make that right. We have certain contractual services. These are pretty straightforward. There's first of all, there's $14,000 for registration fees. That's the actual registration fee of these out-of-state conferences that I mentioned. Then there's a software maintenance, $62,000. That's a normal increase by contract. That's something that's unavoidable that we need to have. So the increase in contractual services, you'll see there, it's a total of $76,000. That's for the increase that we need to have. Also, there's a summary of equipment on the back. By and large, these replace outdated equipment that's necessary. There's a new process server and hard drives for the court. That's $25,000. New storage server for the court, $70,000. Network for the court, $7,000. Laptops, $45,000. And that's for youth courts. That goes to your youth courts for my kids, and that's essential there. Also, miscellaneous parts is $8,000. So and there's a decrease in youth court purchases. They accomplished much of their goals last year with the funding they have. So this is a reduction. We don't ask for more than we need, and that's what that is. So that's a request for an additional $219,000 in general funds, and the total increase of $97,450 because of the reduction in what we spent this year. I want to go back. I inadvertently mentioned it. You failed to mention it. You see, we have 4 PMs. This is on the first page. That is necessary for us. Each of these would be $86,110. Language access coordinator is critical. It's a critical need. The federal government requires each court to have an appropriate translator and interpreter for these activities. And if we don't have that, we could be sued. We want to avoid that. Plus, it's the right thing to do. And the coordinator allows us to acquire those and commit those. We don't have those in Mississippi necessarily. We need to have a dedicated person to make sure we can get what we want. And so that's critical to submit. Also, you see the second one is a cybersecurity specialist. That should be self-evident. We have concerns just like everyone else. The court must remain in operation. It's a constitutional duty. We can't afford, frankly, for somebody to hack us and shut us down even for a short time. I'm proud to say we have redundant systems backed up in other places. We are given to understand it may just be a few days that we're shut down. We're not sure of that. But it would be, certainly for a few days, we would be out of operation, which would be terrible. However, we think that we have something in place for temporary, but that's not assured. We need to avoid that happening. So this is a person that's dedicated to that. You'll also see here an MEC research statistician. We have MEC that's ongoing. We're adding new courts as fast as we can. This will enable us to make sure the data is correct and that we're able to track that and do what we need to do. Finally, a grant officer. Ladies and gentlemen, there are grants available all throughout, particularly by the federal government now. We have no one dedicated to go find those for the judiciary. This is what that would be. So that's a total request, $86,100 for 4 new pens. That's $344,400 in general funds. So we respectfully request. Now, having said that, I'll be happy to answer any questions. Be happy to address anything I've touched upon. And I'm here at your convenience.
Any questions? Ms. Barr?
Yes, Senator, I'm going to sit down if you don't mind. Old legs, you understand.
Thank you, Director. So I was looking at the parent representation.
Yes.
Expansion program.
Yes.
Does your office fund that? And the reason I asked that is because earlier today we had the Office of State Public Defender here requesting money for parent representation as well. So
It generally goes to Andre and his people. It comes through us. It actually is something that Casey funds. They've indicated a willingness to do that. The reason this is on here is again, because they've asked us to branch out and get an additional amount of money for the state to have skin in the game. But you are correct. That's where it ultimately ends up.
So we need to send it to your office rather than the public defender.
Well, yes, it flows through, but that's where it goes. Yes, sir.
Regarding the salaries,
Yes, sir.
looking at you said we did a pay raise for the judges last year.
That's correct.
And your SPV has recommended a pay raise for the judges again this
That's
year.
correct.
What would that take our trial judges to potentially?
It would take the trial judges substantially up. I have that. Senator, I'll have to get you that. It's available, but it's substantial, and that takes them up considerably. I can get that easily for you and be happy to do.
I'd like to get the same for the appellate judges.
Yes, sir. I'll be happy to do that.
For a trial judge.
Chief Justice says 158 for the trial. Yes, sir.
That was a recommendation that made by the personnel board last year, which we did not adopt because of the half-year mission. That's a 6-month-old recommendation. And that's the number that's in the budget, 158.
Yes, sir. We'll get you the appellate.
The 755,000 requests, that's for 7%, the base 7%.
Yes, and we think that's the absolute floor. We would ask you to consider more than that. But yes, sir, that's what that is.
That's all I have, Mr. Chairman. Thank you.
Thank you. Now, how many employees is it? How many employees?
Are thinking about the raise or what?
Yes.
Well, there are, I can give you judicial raises. How many? 145 in our office and around the state. It's, every judge, their court administrators, not clerks generally, because the counties pay for that, but quite a few are affected. And again, the great bulk of this flows to your counties, to your communities.
Okay. You have any other questions? Not, we thank you for coming.
We deeply appreciate it. I hope it goes without saying, if there's further information we can provide, we're more than happy to do that. Just let us know. Thank you for your time.
Okay.
Yeah, if you do, go ahead and give those to him. There goes the mayor.